a recording session, a recorded lecture for part 1, Jual Janji, under week 6. Part 2, we look into equitable assignment. Jual Janji is basically a customary transaction. So when we say it is customary transaction, it is unregistered transaction. It's not registered under the National Land Code. The purpose of Jual Janji transaction is actually to secure a loan for a needy person. The purpose, the amount of loan does not represent the land value, but more or less to help the person who is in need of money. Based on that reason, there is no interest charge in the transaction. Basically, the borrower does not have the cash money, and he does have only a property. So the property is put as a charge for the purpose of the loan. David Wong, one of the eminent legal scholars, shared with us what is meant by Jual Janji. If you look at the definition provided here, it explains about the nature of Jual Janji transaction. So Jual Janji involves a transaction where the borrower transfers the land to the lender, where the lender will take the possession of the land. So whenever the borrower takes the possession of the land, the borrower can also take profit out of the land. The borrower can also allow the lender also can allow the borrower to stay on the land. The period of the loan is basically mentioned in the Jual Janji transaction. So the period or the time is an indicator of the Jual Janji. The borrower is entitled to get back the land upon the full payment of the loan within the period. So when the loan has been paid in full, the Jual Janji becomes Jual Putus. The practice of Jual Janji has been widely exercised among the Malay community. In the case of Tengku Zara and Cik Yusof, the judge recognized Jual Janji as a customary transaction. Therefore, the purpose of the loan is just to secure, the purpose of the transaction is just to secure a loan, number one. Number two, it does not involve any charge of usury or interest, which is prohibited among Muslims. If you look at this case, the judge did not interfere into the agreement between the parties to use English law because the transaction is a customary transaction. Apart from the practice in the Malay community, the transaction is also prevalent in the non-Malay community. This can be seen in the case of A. Kanapati Pillay and Joseph Chong, where the parties to the transaction in this case were non-Malays. Jual Janji, as we discussed just now, is a customary transaction. Customary transaction is unregistered transaction. So unregistered transaction means it is not required for registration under the National Land Code. Alright, to enforce, the contract between the parties must be enforced, right? So here, we look at two situations. The first situation when Jual Janji transaction is not registered. The second one is when Jual Janji can be registered or the parties opt to register the dealing at the land office. Let's go with the first situation when you want to enforce the unregistered transaction, unregistered Jual Janji transaction under the National Land Code or in the Court of Law. Under the National Land Code, Section 206, Subsection 3, unregistered dealing can operate by contractual agreement. In other words, if there is any breach of the terms of the contract, the parties can enforce the contract based on the contract itself. You don't need to invoke the provisions in the National Land Code since it is an unregistered dealing. As an addition, the lender can enter a lien for the caveat to protect his interest in the dealing. In the second scenario, where the party agree to register the Jual Janji transaction at the land office. In the case where the borrower fails to repay the debt, the lender still must need to transfer the property back to the borrower and recover his money. So in either situations, either it is registered or unregistered transaction, under the National Land Code, the parties can still have the right to enforce in law and to put the caveat to protect their interest, meaning that the borrower cannot dispose or sell the land to a third party when there is a caveat on the land. The next slide is to explain on the nature of Jual Janji transaction. Jual Janji is a contract between a borrower and a lender. So you know, as the nature of contract explained to us, that there must be an offer and acceptance and consideration in the contract. So here, the vendor, the borrower, offer to the lender to sell his land at a certain amount and within an agreed duration. When the lender accepts the offer to sell the land, the lender will take possession of the land. In this situation, the lender can allow the borrower to stay on the land. Please bear in mind that the amount of the loan does not represent the amount or the value of the land. But if the amount of the loan is more to help the borrower to get the money rather than to sell the land to the lender. You can say, in other words, there is an element of constructive trust here, but not exactly constructive trust like in English law. In other words, the lender keeps the land for the interest of or for the purpose of the loan. So when the land is transferred from the borrower to the lender will give a cash money to the vendor. And there is also a term in the contract where the purchaser will sell back the land at the same price without any interest when the borrower pays the full amount of the debt. So when the time of the contract has come or has been fulfilled, the vendor, the borrower, will need to purchase back the land within the agreed period, and for the purchaser to return the land title back to the vendor. If the borrower fails to repay the debt within the agreed duration, the title of the land will be transferred to the lender. So Jual Janji will become Jual Putus when the borrower fails to repay the debt within the specified or the agreed period. But the question here is, can the borrower get back the land if he repays the debt to the lender outside the agreed period. On this issue, the Malaysian court have two views. The first view is it cannot be recovered because it already becomes an outright contract of sale, meaning that when the borrower fails to pay the debt within the specified period, the land has been transferred to the lender. Why? The reason is because the time is of essence in the Jual Janji contract or dealing. So when the borrower fails to pay the debt or has exceeded the period of payment, the borrower cannot redeem the land. On the second view, the court says that the borrower can recover the land because it is a customary transaction. It's a security transaction. When it is a security transaction, time here is not of essence, meaning that the land title here can remain with the borrower until the debt is fully paid, although the time is over, although it has exceeded the time limit. So the next part of the discussion, we look into these two different views on the status of right of the borrower when he fails to pay the debt within the specified period. So I will divide the discussion into two parts where you will see that some cases support the first view and some other cases adopt the second view. For the first view, it says that when that happens, when the borrower fails to pay the debt within the specified period, the land will be transferred to the lender because it is an outright contract of sale. A landmark case here is Haji Abdul Rahman and Hassan. In this case, the Jual Janji transaction was registered under the Selangor Restriction of Title Regulation 1891. The problem arises in this case when the borrower failed to pay the loan, and therefore he had problems to redeem the land within the agreed duration. He only repaid the debt after 18 years of the agreed duration. So after 18 years, only the borrower came to the court and filed a lawsuit against the lender to recover the land. The lower court, which is the Judicial Commission, the Courts of Judicial Commission, and the Court of Appeal, deliberated this case based on English principle of equity, which is once a mortgage, always a mortgage. Therefore, the lower court treated the transaction as a security transaction. Based on that reason, the borrower had the right to redeem the land, even though the period has expired or has been exceeded. This case went to an appeal to the Privy Council. The court reversed the earlier decision. The court held that the collateral agreement to retransfer is only effective in contract. So what is collateral agreement here? The collateral agreement here is referring to the failure of the repayment. The failure to repay the land would affect the retransfer of the land by the lender to the borrower. So here, to deliberate on the issue, the court refers to the contract. The court held that the failure to repay within or after the period cannot be allowed. Lord Junadin, who is the leading presiding judge in this case, held that as the borrower did not pay the within pay the debt within the stipulated period, he has no longer any right to repurchase. Therefore, the land will be transferred to the lender. This case, bear in mind, is following Section 4 of the Restoration of Titles Regulation 1891. The decision might be slightly different later. Why? Because there was no longer regulation available after this case because it has been abolished. So it is not quite right to follow this case because the decision of this case was based on a statutory provision. The case of Wong Si Leng and Saraswati Amal followed the decision of Haji Abdul Rahman, where the court held that the English principle on equity of redemption does not apply to systems of title restoration to land. Thus, the judge said that the right of the respondent to repurchase the land did not confer on the respondent any interest in the land, meaning that any right accruing or arising out of the contract must be based on the contract itself. The parties must exactly follow the requirement of time as of essence in the contract. The court in this case held that it had no power to extend the contractual period to exercise the option to repurchase the land because the time has been final. The next case is Muhammad Isa and Haji Abdul Rahman and another. In this case, the borrower, the plaintiff, transferred the land to the respondent. The option was stated to be within 6 years and further extended to another 5 years. In the meantime, the time of the repurchase still existed. The defendant entered into another Jual Janji transaction to the second defendant. The issue in this case was whether the plaintiff could bring up the case for the registered transaction to declare null and void. The court held that the second transaction was void because the selling of the land to another person was not part of the contract. Therefore, the plaintiff has succeeded in this claim. The next case, Kanapati Pillay and Joseph Chong. In this case, the plaintiff entered into a transaction with the defendant, and this case went on appeal at the Court of Appeal, where the respondent sold the land. The respondent here is the plaintiff. Sorry, the respondent here is the lender. The appellant is the borrower. So the appellant sold his land to the respondent to prevent a foreclosure proceeding against him. In the contract, there was an option that the appellant has agreed to repurchase the land at the enhanced price, at a higher price. However, the appellant did not exercise the option to repurchase the land within the agreed time. Sali Abbas in this case held that the option to repurchase here is contractual, meaning that the parties has to comply with the terms of the contract. Any breach of the contract would lead to transfer of the land. Furthermore, he says that even though there was a caveat entered by the borrower, but it was outside the time agreed between the parties. And based on On that reason, the judge held that the transaction was not intended to be a loan, but rather to be a sale. Therefore, the failure of the plaintiff or the appellant or the borrower to repurchase the land within the stipulated period has denied his right to get back the land. Let's look at the second view, where the courts have held that the transaction as a security transaction. So being a security transaction, in the court's opinion, time is not of essence. It's very much similar to the English concept of mortgage. If you go back to the case of Haji Abdul Rahman just now, where the lower court followed the decision or the principle, English principle on equity of redemption, once a mortgage is always mortgage. So that's basically the premise or the stance given by the court, where they relied on the English principle as the basis of their decision to say that Jual Janji is a security transaction. In the case of Yaqub and Hamisa, in this case, as usual, there was a contract between the parties, and there was an option to repurchase the land within the period of 3 years. From the facts of the agreement, the court held that English law could be applied here because it was considered as a security transaction. This case did not follow the Privy Council decision in the case of Haji Abdul Rahman, because the law in Haji Abdul Rahman was already abolished. Therefore, the English principle can prevail when it comes to Jual Janji transaction. In the case of Nawaddin and Muhammad Sharif, the court also held that the transaction was a mortgage to secure a loan. Therefore, the borrower can have the right to redeem the land. And the right to redeem the land was not affected within the agreed time. In other words, even though the time has expired, the borrower still can repurchase or can redeem the land. The next case is Mahadevan and Manilan. Even though the case was decided, the case of Mahadevan and Kanabati were decided by the same judge, but Ali Abbas, the judge in this case, came to a different conclusion for the case of Mahadevan. In this case, Justice Saleh Abbas said that the purpose of the agreement is to secure a debt in favor of the debtor's name. This has created a security transaction. So even though the transaction is not registered under the National Land Code, it's not as a security transaction or as a charge, but it can still be considered as a security transaction based on customary practice. By the way, because it is an unregistered transaction, it does not need to follow the procedure of security or charge under the National Land Code. Jual Janji can be registered and unregistered transaction. Originally, it is unregistered transaction, and generally speaking, it is unregistered because it is a customary transaction, and a customary transaction that involves a small amount of loan. However, there are different effects of law when it comes to registered and unregistered Jual Janji, meaning that you can remain the transaction, you can keep the transaction as unregistered transaction, but you can also opt for a you can opt to register the transaction at the land office. Let's look at the first category where the transaction is unregistered. So for unregistered Jual Janji, where the Jual Janji transaction is not registered under the National Land Code, the vendor will transfer the land to the purchaser. The land will remain on the vendor's or the borrower's name. The purchaser, the lender, can also lodge a private caveat to avoid the land from being disbursed or disposed to a third party, like being sold to a third party. So when you have a caveat on the land, there is a cumbrance where there shouldn't be any subsequent transaction on the land. In the case where the borrower breaches the contract, the lender can sue the borrower for the breach of contract. For the registered Jual Janji, the nature of transaction is the same, where the vendor or the debtor sells or agrees to sell, offers to sell the land to the lender or the purchaser. So here, because it is registered transaction, the purchaser registered the land under his name. So when it is registered, the lender has the indefeasible title which cannot be challenged by any subsequent acquitable or registered purchaser afterwards. Here, because it is a registered title, the purchaser has the proprietary right. In relation to caveat, the borrower can choose to enter or not to enter the caveat. He can choose to enter a registrar caveat, like what happened in the case of Muhammad Isa and Haji Abdul Rahim. If the lender breaks the agreement, the vendor, the borrower can sue the lender. So can you see the difference here between registered and unregistered Jual Janji? In the case of Haji Muhammad Isa and Haji Ibrahim, the lender sold the land to a third party while the agreement of Jual Janji was still subsisting, was still there. The period of payment had also not expired yet. However, the borrower had not entered caveat on the land. The court in this case held that the interest of the borrower was protected under the agreement. Just because the lender had registered the title at the land office, it does not mean that he can enter into a transaction with a third party while the Jual Janji transaction was still there. Therefore, the subsequent transaction between the lender and the third party here was void. And the right of the borrower, the vendor in this case, was protected. In other words, the land, the transaction, the second transaction was not valid. Looking into the two views of the courts on Jual Janji here, the first view says that it was an outright contract of sale, meaning that when the borrower fails to repay the debt within the period, the land will be transferred to the lender. And the second view is that it is a security transaction, meaning that the borrower can still redeem. The borrower can still have the option to repurchase the land, although the time has exceeded. how do we reconcile the differences or the inconsistencies of the court's opinion here? Some courts say you follow view number one. Some other court decided and follow view number two. So here, we have to put ourselves in the position of what is the available remedy to the borrower. In looking into this issue, the court can declare that the borrower has equitable relief according to the English law of equity of redemption. The court also may consider that the transaction was irregular Jual Janji, meaning that equitable relief cannot be granted to if the equitable relief cannot be granted to the borrower, then Jual Janji is a customary transaction. So since if the Jual Janji transaction is unregistered transaction, the borrower can invoke Section 206, Section 4, Subsection 2A, and Section 205, Subsection 1 of the NLC. These provisions all cover for the unregistered dealing, meaning that if the parties would like to enforce the right in law, they can invoke based on the terms and agreements in the contract. And finally, the time issue is not of an essence to an agreement in Jual Janji. That's all for Jual Janji topic. If you have any questions, please put your questions personally to me or in the WhatsApp group. We will have a specific session to discuss further on this during the so-called math tutorial. And you can also leave questions here on the Microsoft Teams. That's all from me now. Have a good day. Assalamualaikum warahmatullahi wabarakatuh.